I'm Cliff Shepard for Legally Informed. For the last 10 years, I've been giving presentations just like this one to the city bodies that I represent. And we finally got smart enough to put this thing on videotape so that people like you, who are either currently on or about to enter into service on some public board or commission, can have the benefit of the mistakes that I've made and those around me have made in trying to comply with this sometimes misunderstood law. So why is this video important to you? Well, over the next 30 minutes, we're going to talk about the reasons why the Sunshine Law is important to you and how you can stay out of trouble. So let's start with this. Most people generally know that the Sunshine Law is about open government, but it's just like your mother told you, the devil's in the details. What you should know is that violations of this law can range from anything from a civil infraction with up to a $500 fine, up to a second-degree misdemeanor with 6 months in jail as a possible penalty for intentional violations. That's no picnic. But guess what? Neither is being investigated. And so a lot of what you're going to hear me talk about today deals with how to avoid the appearance of impropriety that can lead to investigations, which are at best embarrassing and at worst end up in convictions. I hope I got your attention with that word, convictions. It was intentional. This is serious stuff. It is a big deal. And it doesn't matter that you're a volunteer and that your time is valuable and that you're doing it as a public service. You're expected to comply with the law regardless of all of those things. So listen up and let me try to provide you some information on how you can stay out of trouble in dealing with the Sunshine Law. First, you need to understand that it's a politically based law. And when I say politically based, I mean this. The enforcement for it is through a local state attorney who is a political officer and elected to office. And his two biggest constituencies when it comes to Sunshine Law are the media, both print and broadcast. They're the ones who, if they get wind of a violation, will be pursuing the complaints. And because the fact that the violations will get reported heavily, or potential violations will get reported heavily, the state attorneys, they can't afford to look the other way, and they won't. Even if you're innocent of what you're ultimately accused of here, you can count on an investigation. And it is this point of my discussions with my boards that I talk about what I call the food, sports talks, and investigations, oh my. Early on in my city attorney career, I represented a city that used to have early workshops at 6:30 in the evening. And because that was early enough that the members couldn't get home to eat dinner, we usually had dinner brought in, whether it was Chinese food or sandwiches, you name it. And we would sit in a conference room, typically discussing things like sports, Gator football, sometimes Seminole football, Yankee baseball, the Red Sox, those kinds of things, not city business. In attendance at those meetings, in addition to myself, was the police chief. That's important to know because the police chief, had he been observing any Sunshine Law violations, would have had a duty to report us all. That didn't happen. But what did happen is a former mayor of the town walked into the City Hall building, saw through the glass conference doors that we were all eating and chatting, assumed there was a violation, was unhappy with the makeup of the then council, and reported us. 4 months later, we were exonerated. 4 months of newspaper articles, 4 months of witness interviews, 4 months of answering written questions. It was not a fun experience. And it scared me, it would have scared you, and I'm hoping it scares you now that that potential exists. Appearance, appearance, appearance is critically important to complying with this law. Because while the basis of the law is what you're talking about, the fact that you are talking with another member of your same board or commission on what someone assumes will be the business of your agency is enough to get you investigated, and that's no bargain. Concern yourselves with how things appear, not just what you are doing. In this area of the law, which involves always politics at some level, you are one vote away from turning from hero today to villain tomorrow. And if someone doesn't like the way you vote, you can take this to the bank. If they see what they perceive as a violation, you will get reported. You need to avoid the appearance of a problem. So, in order to do that, you need to know what the law says. So what does it say? The meat of the Sunshine Law is only 144 words long. And the fact that it was drafted by lawyers ought to tell you something. Because literally what's been litigated about this law fills volumes of text. Volumes. Only a lawyer could take 144 words and stretch it to this much law, but they did. So what does it actually provide for that you need to know? Well, the three big points. Number one, that boards and commissions are subject to open meetings, meaning public's allowed to attend. Those meetings have to be reasonably noticed, and minutes have to be kept. That's it. That's it. Well, geez, you're saying, Shepard, that's simple. That's not a big deal. What's the problem? Well, it's like your mom told you, the devil's in the details. So we now have to go back through and talk to you about what do these things mean. Let's start with the whole idea of what a board or commission is. For the purposes of this law, when we're talking about a board or commission, we're talking about public bodies at a state or local level, elected boards or commissions, appointed boards or commissions, advisory boards. Decision-making is the key to whether you're covered. If you are involved in the decision-making tree, and I'm going to explain that to you, you are covered. So what is the decision-making tree? If what your body does either recommends, evaluates information for another body, makes suggestions, weeds through candidates for another job, any of those things, you are in the decision-making tree. That is, you are part of the tree, the base of the tree that ultimately leads up to the top where a decision gets made. And if you're in that tree, you're covered by this law. That means specifically for you folks who might wonder, advisory boards, because advisory boards advise. And by giving advice, even though it doesn't have to be followed, you are definitely covered by this law. Why is this important? Well, this is where I talk about what we call the sausage rule. Have you ever heard the expression, you don't want to know how sausage is made, you just want to eat it? Well, the Sunshine Law is a little bit different than that. The Sunshine Law is all about the public's right to know how the sausage gets made. And it's that process that the Sunshine Law is designed to protect. So when you're thinking about, geez, it seems a little excessive, remember that it's the public's right to know that trumps everything else when it comes to policy considerations with this law. What's the next aspect that we have to talk about? What's a meeting? Well, geez, again, you're saying to yourself, Shepard, this is simple. We know the meetings, we get the meetings notices, we know where to go, we show up, we have a meeting. Yes, but that's not all. Anytime two or more of you, two or more members of the same board or commission are in the same place or discussing the same thing, and it has to do with business issues that are likely or foreseeable to come before your board or commission, you are engaged in a meeting. And while that may sound even simple to you, let me elaborate a little bit more. It would include phone calls. It will include letters back and forth. It'll include emails back and forth. It'll include texting back and forth. It will include all manner of conversations to and from meetings while you're walking in from the parking lot or walking out to the parking lot. If you're there talking with another member of your same board or commission about a matter that is foreseeably coming before you, has come before you, and may come back again, any of those, you are covered by the Sunshine Law, and that is a meeting. That's one of those details that the devil is in. I have never been to a city meeting or a government meeting of any kind where I didn't see what could have been reported by somebody as a violation. Before the meeting begins, people talking on the die. After the meeting ends, people walking to the parking lot and having discussions. It happens all over the place. My sincere hope is that those conversations are all above board because they deal with things like football and baseball and Little League and school and soccer moms. But I have a suspicion that just on occasion, there might be a violation going on there. So I want to caution you, that's where people tend to get in trouble. All right. So what does this require of you? We've talked about what a board or commission is. We've talked about what a meeting is. We talked about the fact that minutes need to be kept. And again, even with those definitions, they sound, fairly understandable, but they require you to be constantly on your guard. And if you say to me now, why? I want to harken back to the words I said earlier. You are one vote away from being hero today and villain tomorrow. Don't forget what I'm telling you here. I've seen it happen, and this is what the nature of your business is when you're on a public board or commission. You can never forget the politics. Never. Now, one of the things that I get asked frequently when I give these presentations is, well, I have to talk to so-and-so member before the next meeting. We have to discuss this issue. What can I do? Well, the first thing I tell them always is, don't do it. Simply don't do it. It's not worth it. But if you do, let's go back to the big three. Even if it's only with one member of the same body, have a meeting with reasonable notice and keep notes, keep minutes that are available as public records after the fact. What else do I put on that? Well, when you're thinking about meetings that occur like that, you need to have them in a place that's accessible. So private clubs are out. Private restaurants are out. Public restaurants are out. Private homes are out. You need to have the meeting in a place where the public can reasonably feel that they can be included and would be included without cost to them to see how the public business is being done. So keep that in mind. First answer is don't do it, but if you got to do it, make sure you comply with the statute. Now, I also like to talk here about issues involving how do you deal with the issues that come before you if you can't get more information. I really need to talk to these people. I need to understand where they're coming from, and we can't get it all done in a meeting. What can I do? Well, this is where I can throw you a lifeline. You are free and should readily talk to any member of staff at any time. And it's not a sunshine law issue. Why is that? Because they are not on your same board or commission. They are staff. You can also talk to members of other boards of commission in your same jurisdiction or in other places for input and information. If you were on a planning and zoning commission and wanted to speak to the mayor of your city or town, you would be free to do that, and you should do that. Other members of council, the same way. Any other body in the city, no problem. It's just when you're engaged with the people who are on your same board or commission that there's an issue. So keep those in mind. Use those tools to get yourself informed so when you come to your meetings, you'll be ready. This next part of the video is the part that gives me the most discomfort because it's the area where I think people can have the most tendency to get themselves in trouble, and that's called the exceptions. I would like to be able to tell you in this part of the video, forget everything and assume there's no exception, because if you did that, you're guaranteed to be safe. Assume there's no exceptions. But we're going to talk about some exceptions just so I've done my job. First one is the big exception, and that is the state legislature. And at this point, you've got to be scratching your heads. What are you talking about? Well, the biggest legislative body in the state had the wherewithal to apply this law to all of you all, but exempt themselves. They are not covered. So 2 or more legislators can get together and they can talk about bills and legislation and all kinds of manner of things, including football and baseball. But they can talk about what they're doing in the business that comes before them, and it's not a violation. And frankly, I believe this is because I don't think they could comply. But having said that, that has no impact on you. Here's something else that doesn't impact you. One of the things that I should have said right at the get-go is that people are under a big misconception about the fact that, well, I'm a volunteer. Who's going to prosecute me? I'm volunteering my time. I'm doing my public service. And that makes a difference. But legally speaking, the fact that you don't get a dime makes no difference. The law applies to you just the same. So whether you are Mother Mary and the Sisters of the Poor, or whether you are Bob Bigshot on council, doesn't matter. The law applies to you just the same. Here's something else you need to know. Common sense, even common courtesy, doesn't matter. In this situation, what may make perfect sense to you to do as another human being, if it violates the tenets of the statute, you still get prosecuted. Let me give you an example, again, from the School of Hard Knocks. In one of my cities, there's a financial advisory board, fiscal advisory board. They discuss complicated issues. Sometimes the discussions get heated. And so it happened that on this one occasion, one particular board member got pretty hot with another one, said some things that he later, upon cool reflection, felt bad about. I was not there. but I found out about it after the fact because I was copied on email from that individual to the other individual, which was issuing apology. Miss Manners would applaud at this point. But the reality of the situation is the Sunshine Law doesn't care about manners. The Sunshine Law cares about communication, and the communication of the apology through the email also discussed the reasons why that particular member got so exercised and why they got so upset and why their position was what it was. And it engendered a response. And that means we had communication, we had it outside of a notice meeting, we had it with no minutes, and therefore we had a violation. That's a problem. So with all due respect to Ms. Manners, they don't matter here. If you got to make your apologies, you got to make them in a public setting, in a public meeting, or else let it lay. So heed me on these things. The biggest misconstrued exception is what's called the social events exception. And this is one in which a lot of people take solace. Ah, I found it. This is the one that makes sense. This is the one that says, I can go to a party, I can go to dinner, I can have breakfast, I can do social things and see some of these people that are on my board or commission, and it's okay. And that's true. It's right in the law. Except here's the problem. The essence of Sunshine Law violations is not the where. It's the what is discussed. What are you talking about? So even if you're at the debutante dance with your daughter and you happen to talk to another dad whose daughter is also there, and you start talking about city or agency business, you have a violation, and it's not location that's going to save you. It's what you're talking about that's going to save you. And that's why this is the one, if I said, please erase one particular exception from your memory banks today, that would be the one, because that's where people get in trouble. Remember that. It's not a harbor. It's not a safe harbor because you're at a party or a dinner or a breakfast. If you're talking city business with another member of your board and commission, you have a potential violation on your hands. Position papers are another exception. And this is an area that gets a fair amount of play in some of the cities that I represent. Specifically, we deal with a lot of complicated issues. When you're talking about growth management, when you're talking about alcohol ordinances or how to regulate a bed and breakfast, or you name it, the issues can get very complicated. And oftentimes they require more time than typically we allow for public meetings. So you might have one or more eager beaver members on the body who want to go out and do some independent research. And this is a good thing. They then want to put together position papers. They want to stake out a position and say, this is how they believe and this is how they feel on a certain issue and here's why. And they want to provide that to everybody else to read in advance so they can be educated and be ready to go when the meeting comes up. That is also specifically permitted. But again, the essence of Sunshine Law is communication about these matters. If those position papers engender a response back from someone who may disagree on that same board or commission, you have the potential for a Sunshine Law violation. So, what do I need to tell you about this beyond those things? Well, first, just from a social dynamic that I've observed, one of the things you should recognize is if you're one of those folks who has a desire to put out a position paper to the other members of your board or commission on some issue, recognize that in doing so, you potentially effectively tie the hands of the other board members who may disagree with you from doing the same thing so that they are not engaged in a Sunshine Law violation. While that is going to keep you from having a legal violation, it may create some tensions in the dynamics between you when you're on council or on your commission or board and having these meetings. And they might tell you they don't appreciate it. So I would warn you of that. Secondarily, though, if the issue is important enough to you to put out your position paper, make sure of these things. Make sure it's distributed by staff, not you, to your fellow members, and make sure that you say very clearly and right up front, please do not respond to this position paper except at a publicly noticed meeting. If you do those things, you should be able to avoid problems with position papers. I'm going to move into cautions now. I have a lot of those. And this one is called, Where in the World is Carmen Sandiego? You're all familiar with that issue, that game, Where in the World is Carmen Sandiego? You get geographic clues and someone tries to find where the person is. And I use that as an example to highlight that no matter where in the world you may be, if you happen to be with another member of your same board or commission and you're talking about the business of your agency, you have a violation on your hands. It does not matter that you're outside the state be it in Washington or somewhere else, if you're talking about business that comes before you, you are in violation. And worse, if you come back and it's found out, that can be seen as evidence of the most severe violation, an intentional violation, the kind that gets you a prosecution for second-degree misdemeanor with a potential 6-month sentence. The theory being you left to avoid being detected, and you've now been detected. So bear in mind that whether you're in Washington, D.C., where often people go with some of their fellow members to do lobbying for Congress, or Tallahassee for the same purpose, wherever you are, the law, as long as you're on that Board or Commission, still applies to you. And don't ever forget it. Prosecutions for those things are particularly painful. Now, I want to move into a brief discussion of public records issues and how they affect you in your service as a Board or Commission. They're a different chapter than Sunshine Law, but because of the nature of open meetings, there are parts of it that I want to express to you that are important in doing your service. I have observed many times members of my boards or commissions passing notes. More recently, the phenomenon of texting has invaded some of my bodies. They have their cell phones, their iPhones, and notes are going back and forth, and I know this. And it concerns me, and therefore I want to share it with you. Here's my point. If you are providing a note to anybody else on that body, you should follow the rule your teacher always taught you. Don't write a note that you wouldn't want to have read in front of the other members of your class. Because if someone finds out or sees this happen and requests a copy of it as public record, that's exactly what's going to happen. Let me again give you an example that is close to me. Several years ago, one of the cities I represented had a very controversial development that was in front of it. And it had led to a vote on a particular portion that was equally controversial. Apparently, one of the members on council who brought up an issue for vote assumed that another council member was going to be voting with him. And when that didn't quite work out the way he planned and the vote didn't go his way, he was very angry. They had to call a meeting adjournment because he was so red in the face and so forth, and everybody came back when we thought cooler heads would prevail. Now you might wonder at this point, how would he even know if the person was going to vote with him if he hadn't already violated the Sunshine Law? But that's beyond the scope of this video. What is important for this video is that when he comes back into the meeting and the meeting is back underway, he's still so angry, he goes ahead and writes out on a piece of paper the word Judas, and he underlines it, and then he slides it over to his fellow councilman to let him know in no uncertain terms he's torqued. But the media was there, they saw it, they requested it, and it made front page news the next day. So, note passing, not a good idea unless you want to see it in print. Probably not something that was legally problematic, but was it embarrassing? I would venture to say that the person who wrote the note wishes he hadn't. So keep that in mind and take those words to caution. Another part of public records law you should know is about dealing with emails. As a member of a public body, you may, in fact probably will, get emails from other citizens, lobbyists, who knows, but you'll get them. And if they deal with the business that comes before you, they're also public records. Hopefully your agencies have a repository, a city clerk or a clerk or somebody that you can go to and give the information, the emails that you send and receive, so that they're in a centralized place for record-keeping purposes. But if that's not the case, or if you have emails that you get and receive that aren't sent to others, but that do deal with the agency's business, you must save those. You cannot delete them, and upon request, you must be able to provide them, because as to those records, you are the custodian, and you are bound by the law to make sure that you keep them so that they can be produced upon request. This is very important. Another kind of record that I need you to be aware of is receiving unsolicited emails from other members of your board. You might, by attending this presentation today and watching this video, say, well, why would that happen? Anybody who's seen this will know better. Well, yeah, but that doesn't mean they'll listen. And frequently they don't listen. And frequently you will get unsolicited emails from members of your same board or commission. Trust me, I know. Having said that, what do you do? Well, here's what you first of all don't do. Don't hit the delete button. Because you don't want to engage in a public records violation while you're trying to avoid what you think is a sunshine law violation by another board member communicating with you. Simply don't delete, but don't respond. Don't reply, avoid the temptation, and bring it up at a public meeting if you must, but do not reply and don't delete. That's important. In sunshine law, content is key. Content is key. It's what you're talking about that makes the violation, not where, not when, not anything other than what you're talking about and who you're talking about it with. Remember these things, and you should be able to avoid the problems that confront anyone, any public official who's ever been charged with a violation of sunshine law. In closing, you may be wondering, geez, was he ever going to get finished with this thing? Well, I'm there now. And if I scared you at first, I'm sorry, but not really, because that's my intention. If you go away with enough healthy fear and respect for this law, chances are you have a better opportunity to avoid violating it. The system can't work without good people who volunteer themselves for public service. But the public expects you to know and understand not only your job, but the laws that apply to your job. And they will hold you to it, no matter whether you are paid or a volunteer. When it comes to public service, it's your job to stay legally informed.